Good evening, ladies and gentlemen. I am Iti Agarwal and I have been working with Tax Mantra Global for over 8 years down the line, specializing in Singapore corporate law side of things. Now, over the years, I have had absolute privilege of working with clients across various sectors and helping them in managing their funding activities, navigate through complex regulatory structures while helping them stay compliant and financially efficient. So today I'm really excited to share some of those insights with you. And the topic that I would like to cover today here is owning property in Dubai and the Indian legal risk that you might be overlooking if you are investing abroad. Now, in recent years, what has happened is owning overseas assets has become a lucrative spot for investment. Dubai, in particular, it has attracted a very large number of Indian investments, and the Indian investors, they are actually vouching for Dubai as a lucrative real estate opportunity. So while the process for this, it might seem very lucrative, but there is a hefty compliance burden. And such compliances in these days, they are actually being overlooked by Indians investing abroad. So what most people, they don't realize is actually that Indian authorities, particularly ED, it is now closely monitoring foreign assets and foreign ownership. So how they're managing it? They are managing it through real-time data exchanges that the governments have made pact and the governments are exchanging between them. Then there is digitization. Then there is global data leaks, Panama leaks that happened a few years ago. And so these actually gives Indian government an ample opportunity and an easy access to much more information that was ever available. So my friend, Indian government is getting data almost on real time basis. So while these investment, it might feel secure, they could actually potentially expose you to legal risk under different Indian laws. So in this law, we will help you sort this out. We will break the legal framework. We are going to highlight common mistakes that the investors are making, and we will help you walk through these real risks, including property seizures or tax penalties, what is happening, and prosecution, whatever is coming into picture. We are going to give an insight in this video. Now, moving forward, we would like to first of all make you understand what laws are going to come into picture if you are investing overseas abroad, overseas. So the Indian laws that has come into picture is FEMA. FEMA actually governs how money is moving in and outside of India. So if you are buying a property abroad, it must be funded through legitimate channels, through the channels which are approved by RBI. Anything out of the purview of those law, it will lead to violation. The second is Black Money Undisclosed Foreign Income and Assets Act. So this law is actually aimed at Indians who fail to report their foreign holdings. So if you are owning a property in Dubai and if you have not disclosed in your ITR, then my friend, Black Money Act will come after you. Then there is PMLA. PMLA is Prevention of Money Laundering Act. So what this law actually looks after, this law looks after that your overseas investment, if it is funded through unaccounted or undisclosed income, if such channels have been used, then you will fall under the scope of money laundering and the department will come after you. Now, what they're seeking, they're just seeking one transaction, one questionable transaction or funding source that is unaccounted or undisclosed. Then, my friend, PMLA, you are violating PMLA, and the department is ED is coming after you. And the next is Income Tax Act. The Income Tax Act, an act which we have to deal every year, and it also applies to your foreign income as well. So if you are earning any kind of income, you will have to disclose in your ITR. So if you are also earning any income overseas and you have spent already in overseas, my friend, you will also have to report such earnings in your ITR. So basically, these laws, if you say, these are very serious on its own, and together they form a real strong legal framework. And in the eyes of law, ignorance is not a defense. So if you have bought property anytime, say today or 10 years ago, or say if you bought property a couple of years back, this law will apply to you even today. So time of matter, it doesn't matter anyhow. Whenever you're buying property, you will have to report it to. Now, next is, let's explore why ED is cracking down on Indians who have owned properties overseas. So first is fire violation. FEMA violations is a common scenario. So most of the common violation is FEMA, and it actually happens pretty unintentionally. So say for example, your funds are not routed through LRS. RBI law says that if you are sending money from India, it has to go through LRS. LRS is limited remittance scheme. So, say many people, they are actually unaware about the LRS, either because they think it's too complex or they fail to comply LRS. But under FEMA, all foreign property purchases by Indian resident, it must be routed through LRS. And if it is not routed through LRS, FEMA might come after you. And LRS actually also has a limitation for individuals who are sending money from India to abroad. They can remit up to 250,000 US dollars per financial year under automatic route. Anything above that, it should go via approval route from RBI. Then, how you're violating FEMA, you are using unauthorized funding sources like NRE and NRO accounts. My friend, NRE and NRO accounts are such accounts, it has actually been typically designed for NRIs. So if you are by any chance holding NRE and NRO account and buying any property overseas, all your foreign property purchases, it must be routed through LRS, and you cannot misuse them, and you cannot make any kind of NRE or NRO account transactions for buying properties, being an Indian resident. Misusing such, it will violate FEMA provisions. And the next is lack of RBI approval or missing disclosures. So in some case, there is pretty large transactions or joint ownership which actually require RBI approval or at least proper filings. Skipping these formalities, say if you have exceeded 250K LRS thing and you have not taken RBI approval, then these formalities, if you're skipping these, even unknowingly, it can attract ED scrutiny. The next point the next point on why ED is cracking down is unreported foreign assets, such as income tax and black money act. So how we are missing it? You, when you're investing abroad, say you have not reported your foreign properties in ITR, particularly in Schedule FA. So if you have not mentioned any of your assets in Schedule FA of your ITR, then it's a red flag. And you have not reported under Black Money Act. So if you haven't earned any income yet from property, but its mere existence must be declared. Failure to do so, it will trigger Black Money Act, which includes both financial and criminal penalties. And if you've not declared any kind of your rental income, say you have bought a property in Dubai or US, and you have started earning rental income, but you have not declared such rental income in your ITR, then this will open door to major enforcement action. my friend, you're putting yourself in danger. Then there is insufficient documentation, like you have not filed Form 10F or you have not taken TRC. Then what will happen? Your claim for tax credit, it will be denied and your case will be flagged as potential tax evasion attempt. This will obviously open door for audits, and it will the department will send you notices, or even an ED investigation might also come into picture. So all we can say is ED is acting because more people are unknowingly or carelessly they are flouting Indian laws while investing abroad. So this, as we have discussed, it is happening due to global data sharing, and now authorities are actually detecting non-compliance quickly, and this is absolutely targeted. It is data driven and it is legally backed. Moving forward, what we should avoid, what common mistakes we should avoid. So what common mistake we should avoid is we should not use NRE NRO accounts. We should not use any methods by which we are bypassing LRS. So when people don't fund the don't use or don't send funds through LRS route, say for example they are using some corporate channels, they are using from third party accounts, or they are sending money from their family members, then they are directly violating FEMA. What will be the implication? The implication will be that these transactions, if are not reported to RBI, and if RBI finds out, this will attract penalty up to 3 times the amount remitted. Now, say for example, if you are remitting 2 CR, or if you bought property worth 2 CR, and the department is suspicious of the funding way, then the penalty can rise up to 6 CR. That's how the serious the law is. Mistake number three that people are doing is they are not disclosing loans for their foreign property. Now, if you've taken any kind of loans from offshore entities such as foreign banks, friends, or any kind of related party to buy the property without actually declaring it to the RBI or income tax authorities, then my friend, you are making a huge mistake, because all ECBs or any kind of financial transaction which has involved foreign lenders, they it must follow RBI rules. So if you are not doing it, then such undisclosed loan will be treated as suspicious or unauthorized foreign liabilities, and again it will open door to ED notices. It will you might be charged with, under Prevention of Money Laundering Act and what not. I mean, department will come after you. The common mistake, number four, that has been reported is unreported foreign income. So if you bought a property, the next mistake that you're doing is actually failing to report any income if it has started generating. Say for example, rental income. If you have taken rental income, if you are generating rental income and you are subsequently paying some of it through your some of it or all of it on your expenses only. Say you are paying it for your EMIs, for your whatever loans you have taken, and you are using your rental income to set off that, then my friend, you are making a mistake, because if you are an Indian resident, under Indian tax laws, your global income is taxable and you must declare it in your ITR under Schedule FA. More importantly, all your foreign income should be repatriated back to India. If you are not doing so, then you are making a violation of Indian laws, and non-reporting it will trigger Black Money Act provisions and also criminal proceedings. And mistake number five that we've already discussed is you have not taken key documents. Yes, like you have not filed Form 10F, or you have not taken a TRC. You are unable to take DTAA benefits. Then without this, income tax department, it will deny you tax credit, and it will raise flag, and your foreign income will be suspicious, and it will trigger investigations. Moving forward, we would like to now cover on what are the risks and what are the consequences. So risk, as I've discussed, if FEMA penalties, it will attract up to 3x, sorry, 3x of your transaction value. Then if you are violating PMLA, and it actually brings a higher level of risk, and the consequences are ED can attach your property, ED can freeze your bank accounts, or you can face long run investigations, or even worse, even arrest can also come into picture. Then there is Black Money Act. What mistake here, what risk and consequences are there? Black Money Act actually is one of the most strictest legislation under Indian's legal framework, and prosecution is imprisonment up to 10 years. Now, if you fail to report your foreign property or income under this act, then the consequences will include prosecution with imprisonment up to 10 years, 100 to 300 penalty on the value of undisclosed income or asset, media exposure, which can cause severe reputational loss in professional and personal circles. So while buying property in Dubai or overseas, it is important to understand these laws. It is important to understand that where the consequences, if you are failing to report consequence, the failing to report, the consequences aren't something which is simple in nature. If you have made mistakes, whether knowingly or unknowingly, by not filing the right form, ED will take into consideration that this has been done to evade tax, to mistake, to violate the provisions of the act, and department will not spare. So moving forward, we would like to discuss how we can fix this. Point one, we have to conduct a compliance audit. So we will have to review full investment. We can call it a compliance audit, at how you're funding the property. Did you use the LRS route? Are you missing any kind of RBI filings? Have you missed any kind of disclosures? Have you missed any kind of ITR filing? Are you bringing your are you bringing your foreign income which has been earned outside back into India? Are you declaring all those things? Such compliance audit forms the foundation, and you can fix whatever you haven't when it is assessed. Step 2 should be file 10F and obtain TRC. 10F and TRC, these are essential document under DTAA. And without these, your income will be taxed twice. Once in the country where you bought the property, and once and in India also. So you and your foreign ownership, it could appear really suspicious to the Indian authority. Filing this will actually build a layer of legitimacy and ensure tax credit claims are accepted in India, and your transaction will not come under the suspicion lens of the Indian regulatories. Then there is the step 3 that you should take is disclose your foreign assets in your ITR. So if you have not disclosed your Dubai property in Schedule FA of your income tax, and then it will create problem, and you might have to amend previous year's filings if necessary. So it is actually better to correct voluntarily than to be forced by a notice. Step number 4 is review your source of fund and regularize structure. So actually the main concern of ED is, where did the money come from? So you should be able, in case ED has raised any concerns, so you should be able to demonstrate clean money trail. Ideally, it should be routed through LRS, or it should be fully taxed and completely declared in India. If you have used your family funds, or if you have used your personal funds, if you have used any kind of loan, make sure these were legally structured and documented. So why all these will help you present your case in your favor, and the cleaner your paper trail will be, the safer you will be legally. The next point is how we are helping you. So far we've talked about the laws, the mistakes, and how you're going to fix it before everything escalates. So let's be absolutely honest. This is not something which is a cakewalk, and handling everything alone is pretty overwhelming. So this is where TMG comes into picture, and we've worked with various Indian HNIs. We have worked with startup founders. We have worked with various professionals across the globe to help them invest on their own, or to help them take investment, maintain overseas properties in full compliance as per the Indian and overseas norms. So let's help you walk on how TMG is helping. So first of all, we will absolutely help you in cross-border due diligence. Our first step will be to help you understand what's actually at your risk. We will do a compliance audit for you. We will see how you have purchased your overseas property, your purchase trail, ownership structure. We will assist you in reviewing your LRS, making your FEMA compliances, mapping your ownership documents and disclosures, tracing and verifying your funding routes. Then we can file Form 10F and TRC for you, and we can actually help structure property ownership in line with FEMA, income tax, DTAA regulations. This will help you ensure that everything from your holding to your company owned company to your every compliance is legally sound and future ready. So this is how TMG will help you. We can also help you in legal defense and representations. We can help you in drafting replies. We can help you. We can represent on behalf of you to various regulatory authorities. We can offer defense strategy in such high stake cases. So overall, you can say TMG will become your legal shield here. And so all I can say is we don't only check boxes, we build risk-proof solutions for our clients with overseas interest. Whether you're investing already on your own property or just realize that you have missed something, just you can approach TMG and we will work with you from your risk to your resolutions. So all we can say is that the key takeaways from this video has been point one, compliance is the key. You have to have a proactive approach. You will have to assess if there is any kind of misreporting that you have done, or you have knowingly or unknowingly violated any norms. Then you have to address your issue before they escalate. And thirdly is you can and you must seek expert advice. So, in to sum this up, we all I can say is that at TMG we understand your cross-border investments and where, when, and how this is coming across, what compliances, what complex legal tax or regulatory challenges that you might enter into or you might overcome. So our team, which specializes in helping Indian residences and business stay fully compliant while protecting your global wealth. So whether it's structuring your Dubai property or filing right disclosures or responding to ED notices or income tax, we are here to guide every step. So if you're looking for a peace of mind, clarity, confidence in your overseas holding, talk to TMG. Let's make your compliance your stronger assets. With this, I conclude my video. Thank you, ladies and gentlemen, for staying with us and listening to us. Thank you.